Now, some senior lawyers have been speaking to Law Weekly about Justice Bukachuwa's tenure and some reforms that could aid speedy dispensation of justice, especially at the appellate court. We have their views up next.
She made an history. At least for the first time we had a female president of the Court of Appeal, and since 1976, it's unfortunate that it was only her that became the first female to be president of the Court of Appeal. Then and within the period, it's been a glorious period for the Court of Appeal. There are a lot of reforms. We had this fast track criminal appeals. It's a period that administration of criminal justice law, administration of criminal justice in Nigeria was as a boost because we have accelerated hearing of our appeals. It was never like that before. So before we used to have appeal that will last for 4 years, but within those former governors, our appeal lasted for 6 months. And they were all with five brief, everybody, the court took arguments and judgment were given within 6 months in all those. So these are things that were not, it was not like that before. So it was a great improvement during our tenure, and we really enjoy the reform that she carried out. But the aspect that I think we need to do more is that the justice of the Court of Appeal were being overworked, and then the aspect of electoral thing. The court, the judiciary is getting too much involved in electoral matters, so that we have little or no time for other cases. It's a problem that courts have been involved in the issue of election or who's to be candidate of a political party. Our forefathers, they have their wisdom in saying that anything political, courts should abstain from it. I think we need to go back to those areas.
She creditably discharged the responsibilities of that office to the best of her ability. Within this period, it's of note that she had created more divisions in the Court of Appeal, and she has also improved the staffing generally of the Court of Appeal. Cases are duly more easily filed these days, more easily processed. But one area that probably we would need improvement is in the area of congestion of matters. I know that we operate a democratic system under which you have so many appeals arising from pre-election, post-election matters and disputes. So, as we embrace democracy, as we embrace rule of law, electoral system, and electoral reforms, we should also ensure that we take into account the capacity of the judiciary to deal with such matters. What that would mean is that we need to double the existing capacity at the Court of Appeal. We need to have not just more divisions, because some divisions hardly have matters going there. What we are more interested is working out the acceptable ratio of number of judges, number of justices, and to the number of matters pending. Number of panels as opposed to number of matters on the cost list. We need to have more panels in some zones. For instance, in Lagos, we have just 2 zones. No, it's not sufficient. We need up to 6 zones, 6 panels of that court sitting at the same time. That is the only way we can decongest.
I must tell you that she's had a very successful tenure of office. She is very hardworking. She's very down to earth. What she bothers about is her concern, is how justice will be best served. And then to that extent, she has taken it upon herself to ensure that she's brought justice closer to the people. What am I talking about? Now, during her tenure, she's succeeded in creating additional divisions of the Court of Appeal. So she's really done excellently well. The whole essence of justice is to bring it closer to the people so that people would spend or will care less expenditure in the process of seeking for justice. She has done excellently well. It is work in progress. My lord has come, she's done her own. I've mentioned that she's really brought justice closer. People created a lot of divisions. When the next person comes, what we will look at is how do we introduce automation and technology into some of these things so that everything does not have to be done manually. I think that area we need to look at it.
And just before we go, let's look at some of the top legal stories we're tracking at this time.
We begin with the report that the Supreme Court has dismissed an application filed by Mr. Emeka Ihedioha, the candidate of the People's Democratic Party in the Imo State governorship election. In the suit, Mr. Ihedioha asked the Apex Court to review its judgment which sacked him as governor. The suit was dismissed in the majority judgment of the 7-man panel of judges led by the Chief Justice of Nigeria, Justice Tanko Muhammad. 6 of the judges on the panel agreed with the Apex Court's verdict, while Justice Chima Nweze gave a dissenting judgment, stressing that the decision ought to be reviewed. Justice Nweze held that the court has the power to overrule itself in a situation where such a judgment was not seen to have met the justice of the case. INEC had declared Mr. Ihedioha as the winner of the March 9, 2019 governorship election in Imo State on the grounds that he won the majority of lawful votes cast at the governorship poll. Meanwhile, the Governorship Election Petition Tribunal and the Court of Appeal, during appeals filed by Senator Uzodimma, gave a concurrent decision, upheld Ihedioha's election and dismissed Uzodimma's petition on the grounds that he did not prove his allegation against the election of Ihedioha. But the Apex Court held otherwise and sacked Mr. Ihedioha on the 14th of January. In other political stories, the national chairman of the All Progressives Congress, Adams Oshiomhole, has appealed the court judgment that suspended him as the national chairman of the party. He filed the suit on Wednesday, the 4th of March, hours after a Federal Capital Territory High Court granted an order of interim injunction restraining him from parading himself as the APC national chairman. In the notice of appeal filed on 4 grounds, Oshiomhole faulted the whole ruling of the trial court which granted the motion on notice of interlocutory injunction. Amongst other claims, he alleged that the trial court erred in law and arrived at the wrong conclusion, which occasioned a miscarriage of justice when it decided the question that his performance as APC national chairman would interfere with the party membership rights of the 1st to 6th respondents in the suit at the interlocutory stage. Oshiomhole, who filed the appeal along with the APC, therefore sought an order of the appellate court to set aside the ruling of the trial court. Justice Danlami Senchi, who granted the injunction to restrain Oshiomhole, held that the political parties must be bound by their constitution and that having been suspended by his ward, Comrade Oshiomhole is restrained from functioning as the national chairman of the party pending the hearing and determination of the substantive suit. The judge granted the order at the instance of 6 party members who have been demanding the removal of Oshiomhole on the grounds that he's failed in his duties of providing quality leadership for the party. In Lagos, the Federal High Court has fixed April 24 for its ruling on the final forfeiture of 2 properties belonging to the former President of the Senate, Dr. Bukola Saraki. The Economic and Financial Crimes Commission, EFCC, is seeking the final forfeiture to the federal government of Dr. Saraki's properties situated at number 17 and 17A McDonald Road, Ikoyi, Lagos. In the application for the final forfeiture of the properties, counsel to the EFCC, Nnemeka Omewa, told Justice Mohammed Liman that the properties were acquired with a loan obtained from a commercial bank and paid back with money suspected to have been diverted from the coffers of the Kwara State government. The former Senate President, through his counsel Kehinde Ogunwumiju, senior advocate of Nigeria, has however asked the court to reject the application by the EFCC. The counsel argued that the EFCC has not been able to prove that the money used to pay back the loan was acquired through illegal activities. He also told the court that the EFCC had litigated on the same properties before the Code of Conduct Tribunal all the way to the Supreme Court and had lost. And we round up with the report that the EFCC has called its 5th witness in the 2.2 million naira fraud trial of former Ekiti State Governor Ayodele Fayose. The witness, a banker, Johnson Abidakun, who worked as head of operations at the Ado-Ekiti branch of Zenith Bank, told Justice Chukwujeku Aneke how the bank moved the sum of 200 million naira from the home of Fayose sometime in April 2016. Led in evidence by the prosecuting counsel Adebisi Adeneye, the witness said that an associate of the former governor, Abiodun Agbele, who is named in the body of the charge, subsequently gave instructions for the money to be credited to a company called Still Earth Limited. On the cross-examination by defense counsel, Mr. Ola Olanikbekun, senior advocate of Nigeria, the witness told the court that he did not personally see or hear from the former governor before acting on the instructions to move the money.
And that's our program this week. Thank you very much for watching. Be sure to catch the repeats on air or watch via our YouTube channel. I'm Shola Shiyeli. See you next week.